Good morning to our viewers today. We will bring to you the UST Department of History third webinar. And before we begin, may I call the Master of Ceremonies and Moderators for this session, Assistant Professor Emilita Samala, and Assistant Professor Lisa Yanga.
Good morning, Sir Jerry.
Good morning
Good
po,
morning.
Ma'am
Good
Emmy and Ma'am
morning.
Yanga.
Good
Good
morning, Ma'am Emmy.
morning.
Good morning, Jerry.
Good morning to our viewers. Before we start our session, let us begin with an opening prayer to be followed by the Philippine National Anthem. Altogether, let us pray. Dear Lord, we are all gathered by technology and internet connection to seek knowledge on the topic that we have today. Please guide our speaker and reactor so our participants may understand and learn from this topic that has evoked so much reactions and emotions from the Filipinos. Let this webinar gives clarity and directions to the uncertainty and worry many have felt. Let the truth be in our midst. To you, we offer the best of what we have for the glory of your name and the university we are serving. Amen.
To formally start our webinar today, may I call the chairperson of the University of Santa Tomas Department of History, Associate Professor Archie Rezos, PhD, for his opening remarks.
Magandang umaga, Liz, and magandang umaga, Ma'am Emmy. Magandang umaga sa lahat ng mga taga-subaybay natin sa ikatlong webinar series ng Departamento ng Kasaysayan ng Pamantasan ng Santo Tomas. Ako po si Professor Archie Rezos, ang tagapangulo ng UST Department of History, at ikinagagalak ko po na ipakilala sa inyo ang paksa na ating tatalakayin sa umagang ito. Isa pong maliit na kontribusyon ng aming pamantasan at gayon din po ng Departamento ng Kasaysayan na palawakin ang ating kaalaman sa nakaraan at sa mga napapanahong isyu ng lipunan. Ang unang webinar series po natin ay ginanap noong June 15, 2020 kung saan ang tema ay tungkol sa ika-122 na paggunita po ng Proklamasyon ng Kalayaan ng Pilipinas. At gayon din naman po, ang ikalawa naman ay ginanap noong ika-4 ng Hulyo 2020 na may paksa po na ika-74 na paggunita ng kalayaan mula sa Amerikano. Ngayong araw na ito, isang napapanahon na paksa ang ating matutunghayan na may kinalaman sa pros and cons of Anti-Terrorism Act of 2020, a historical overview and legal analysis. Dito ay matutunghayan natin ang magandang maidudulot nito kasama ang masamang epekto din naman na hatid nito sa bawat mamamayang Pilipino. Ang talakay na ito ay inihahatid sa atin ng isa sa mga historiador at abogado ng departamento, walang iba po kundi si Atty. Edelberto Bunquin. Nawa po ay makapaghatid kami ng kaalaman at kaliwanagan tungkol sa paksa na matutunghayan natin. Muli, Magandang umaga po sa ating lahat.
Thank you very much, Dr. Resos, for your very warm and inspiring message. And now, to introduce our resource speaker for this morning, Lisa, please do the honor to introduce our presenter for this session.
Yes, it's really my honor. Thank you, Ma'am Ellie. The Anti-Terrorism Act of 2020, wherein the intent is to prevent, prohibit, and penalize terrorism in the Philippines. The law was signed by President Rodrigo Duterte on July of 2020 and effectively replaced the Human Security Act of 2007 on July of 2020. Petitions are piling up at the Philippine Supreme Court to overturn a new anti-terror law championed by President Duterte that could jail suspects without charge for up to 24 days. But what are the pros and cons of this new law? Very timely that we have this webinar whose topic is about this Anti-Terrorism Act. It is my honor and privilege to introduce our speaker for this morning. But before that, may I just give you a short background of our speaker. He's a colleague from the Department of History, immigration consultant, trial and litigation lawyer, wherein the areas of practice are immigration assistance and proceedings aliens, naturalization, citizenship, conversion of the visa, and some family laws, annulment, divorce, and civil and criminal cases. He completed his Master in History in 2004 at the University of Santo Tomas. He also finished the Master of Laws cum laude in 2016 and currently a candidate for the degree of Doctor of Civil Law in the same institution. His focus of study is the naturalization of aliens and the annulment processes in courts and other offices in the Philippines. He is also a member of LAWASIA, a regional association of lawyers, judges, jurists, and legal organizations which advocates for the interests and concerns of the Asia-Pacific legal profession. He was engaged in the practice of law, court trial and litigation, land titling, taxation, and criminal laws since 2006. He served as legal consultant in different companies in Metro Manila and the provinces. At the University of Santo Tomas, he served as external legal consultant in the Center for Cultural Conservation of Properties and Environment from 2006 to 2008, and external counsel of the UST Museum from 2009 up to the present. Our speaker is continuously teaching at the University of Santo Tomas, España, Manila, handling the subjects in political law, government and constitution, taxation, and other history and social science subjects. He is an accredited marketer with a Philippine Retirement Authority number 18-049. Our resource speaker is an active member of international, professional, and legal organizations. And this is the reason why he had series of studies and travels abroad. United States, Canada, Singapore, China, South Korea, Japan, Brazil, Amsterdam, Milan, and some parts of Europe, to name a few. His travels are for pleasures, studies, and scholarly activities. He served as Chief Municipal Legal of Puerto Galera, Oriental Mindoro from 2007 to 2012, and the Chief City Legal Officer of Calapan City from 2013 up to 2016. Currently, he is the incumbent president of Rotary Club of Puerto Galera Bay, Transformer Year 2020-2021. He is an author of 2 college textbooks, namely Essential of Politics and Government, or POLGOV, and Economics, Taxation, and Agrarian Reforms, or ETAR, which are now used as mandatory and major references for college students in Metro Manila and other colleges and universities in the provinces. Ladies and gentlemen, colleagues and friends, may I present to you Assistant Professor Attorney Edelberto C. Bunquin.
As of this moment po, nagkakaroon lang tayo ng technical difficulties, pero gayon pa man, maya-maya ako makakasama natin si Attorney Bunquin. At alam nyo, Ma'am Emmy, Ma'am Lisa, talagang napapanahon kasi itong tatalakayin natin na ito. As you all know, naging controversial itong Anti-Terrorism Act na ito of 2020. Kasi di ba ho, maraming sektor ng lipunan natin, lalong-lalo na po mga estudyante, mga professors, na talagang lumalaban sila sa pagkakatatag po, pagkakaroon po nitong Anti-Terrorism Act. Kasi nagugunita po nila yung nangyari nung panahon ng martial law na kung saan mapaghinalaan ka, magkaroon ka ng pagkakasala o nag-comment ka ng hindi maganda sa pamahalaan, sila po'y dinadampot kagad at nakukulong. Kaya nga dapat makita natin in a balanced way na i-deliver sa atin mamaya po ni Attorney Bunquin. Ano po yung aspetong legal? Kasi historian yan si
Yes po.
Diba, Ma'am Emmy, matagal na rin nating nakasama sa departamento po siya.
Oo naman. Kaya natin yan. Talagang pakikinggan natin. Hindi lang yung pagiging historiador niya, kung hindi yung kanyang legal mind. Dahil siya ay isang abogado at naging abala sa mga gawain patungkol sa mga bagay-bagay na pambatas. Kaya kung si Atty. Bunquin ang ating mapag-uusapan, dalawang bagay talaga yung naiisip natin. Yung talino niya sa kasaysayan at yung talino niya sa abogasiya. Kaya excited ako marinig itong mga talakayan na ito. At sana naman makapasok na si Atty. Bunquin sa ating studio para nang sa ganun ay makapag-umpisa na tayo ng ating talakayan. Kung mamarapati ng ating mga tagapakinig, alam natin na posibleng marami tayong mga katanungan na matatanggap. Maraming mga gustong maliwanagan, maraming mga taong gustong malaman ano ba ang pros and cons nitong anti-terror bill na ito. Maraming taong talaga namang mainit na mainit pagdating dito sa issue na ito. Kaya kailangan natin ng isang abogado at historiador para nang sa ganun, mabigyan tayo ng magandang paliwanag o diskusyon kung ano ba talaga yung mga panig na dapat nating mapakinggan para magkaroon tayo ng balansyadong pagkakatuto tungkol sa bagay na talaga namang pinag-uusapan sa buong Pilipinas. Simple man ang tao, may pinag-aralan, saan mang level ng buhay nang galing, talagang namang interesado sila sa ganitong mga klase ng paksa na ito.
Tama. Alam niyo, Ma'am Lisa and Ma'am Emmy, gusto ko pa man sana kung magtanong sa inyo ng pananaw ninyo. I think nandyan na po yata si Attorney Bunquin, kung di po ako nagkakamali. Welcome po, Attorney Bunquin.
Welcome, Attorney Bunquin.
Morning.
Good morning, Attorney. Okay na po, Attorney. Naka-queue na kayo. Pwede po kayo magsimula.
May audio difficulty pa yata na encounter si Attorney.
Opo. Yun nga ma'am, kanina sinasabi ko po na, pero marami nagkukumpara tungkol po sa panahon ni Marcos, panahon po ni Pangulong Duterte, medyo may pagkakahawig po kasi, lalong-lalo na doon po sa mga nagbibigay ng kanilang mga opinion ngayon na hindi yata daw makakabuti itong Anti-Terrorism Act of 2020. Kasi pwede pong mapaghinalaan lang o kaya ako mapagbintangan o ikaw bukal lang nagsasabi ka doon sa pamahalaan natin ng pagbabago, damputin ka kagad o kaya ikaw po makulong. Pero maganda 'di ba Ma'am Lisa, malalaman natin in the legal way ano ba talaga ang mga pros and cons nito para makita rin natin makita din natin yung maaring ikasama nito sa ating lipunan. Tama ba 'yon, Ma'am Liz?
Opo, paano siya makakatulong talaga sa common people, sa mga pangkaraniwang tao. At saka maidagdag ko din nga, sir, ang medyo isa rin sa kinatatakutan talaga ng marami regarding this Anti-Terrorism Act ay yung council na binubuo So karamihan sa mga council, 5 members na galing sa executive, galing sa cabinet member. So yun actually yung isa sa kinakatakot ng marami na syempre kung ito ay under the executive department at ikaw ay against the government, so malaki yung possibility na ikaw ay tawaging terorista. Kasi ngayon talagang kinakrakdown ng marami yung mga naglalabas na nga lang ng mga sentimiento nila sa FB, sa social media. So kaya talagang maganda itong topic na to, the pros and cons. Ano nga ba talaga yung mga epekto, masamang epekto at kagandahan ng batas na to para lalo na sa mga pangkaraniwang tao?
Sa ngayon kasi po, hindi pa natin nakikita yung epekto, no? Kasi kapapasa pa lamang po. Pero, can you share your insight po nung panahon ni Marcos? Ma'am, biro lang po. Joke
Sino
lang
tinatanong mo, sir? Si Ma'am Emmy?
Opo.
Hindi, ikaw yan, Lisa.
I think si attorney Bunquin talaga yung sasagot noon.
Ay, oo. Mas alam na alam ni Atty. Bunquin.
Oo, tama yun.
Pero nakikita naman ng mga audience natin na talagang live po itong ginagawa natin. Kasi minsan talaga may mga technical difficulties, nawawala ng internet. Kaya nakikita nyo po live po itong presentation natin. Di ba, Ma'am Liz and Ma'am Emmy?
Yes, tama yun.
Ay, nakakatuwa lang talaga ngayon, kahit nasa kanya-kanya tayong bahay, talagang pinagsasama-sama tayo nitong technology. Ayun, katulad nga nito, StreamYard, ang ganda-gandang, although sabi nga ni Jeric, hindi siya application, so it's a website, it's a web page. Ang ganda, nakakatuwa kasi lumawak din tayo. Hindi lang tayo basta-basta nasa eskwelahan o sa mga institusyon, that we can connect kahit tayo ay nasa bahay-bahay lang natin.
Ayan na yata po, mukhang pumapasok na ang live feed ng ating pong abogado ng bayan, si Atty. Bunquin. Hello, good morning po, Attorney.
Attorney, good morning. Mukhang di niya pa naririnig talaga.
Attorney Ed, gandang umaga.
You're on, Attorney.
Baka po pinutol yung linya dahil anti-terrorism po yung kanyang...
Ang kanyang tatalakayin.
Di naman ho siguro, no?
Oo.
Ito pa rin, nakikita pa rin natin si Attorney.
Attorney, can you hear us? Just make a wave, Attorney. Nawawala siya talaga.
May problem.
Oo, mukhang napuputol si Attorney.
Pero gaya nga ako sinasabi nila, ma'am, nung panahon po ni Pangulong Marcos, panahon po ni Pangulong Duterte ngayon, talagang meron hong parallelism o pagkakahawig nakikita, no?
Talaga naman.
Sa mga naging vocal na lumaban po sa panahon ng ating Pangulong Marcos. Ngayon din naman po yung nagvo-voice out ng opinion nila, no? Parang isa rin po yung sentimiento at yung na-experience po ng taong bayan. Bagaman, gaya ng sinabi ko po, ito po ay sinabatas Kaya nga sa point of view po ng isang historiador, kasama na rin po yung atin pong yung atin pong abogado, makikita natin in a balanced way po kung paano po makakatulong. Kasi hindi naman natin madi-discount yung fact, meron din pong tulong yan. Pero at the same time, may repercussion po yan. Kaya po yung mga audience natin, binabati po natin na pwede po makita siguro, ma-flash natin sa screen yung ating pong mga audience na bumabati para po makita natin live talaga po tayo.
Attorney, Doc, basahin ko lang, nakalagay dito, V, good morning. John Paul Egalin Abeleria, good morning. Marieta Madrid, siguro taga Spain to, no? Good morning. Si Doc Arlene Calara, makabuluhan at napapanahon na paksa. Kay Marlon Villarin naman, dapat andito si Ma'am Cabrera, saksi sa martial law. Si Ma'am Leti, oo nga, dapat na-invite natin. Melanie Magpantay, good AM po. Paulo Cabling, nais ko lamang pong batiin ang aking dating guro na si Chair Doc Archie Resos.
Good morning, Paulo.
Dami mga pagbati
Oo nga po Naku, talaga excited na ang lahat na marinig ang pros and cons of the Anti-Terrorism Act. Pero totoo yun, no, Doc Archie, makikita mo talaga may parallelism yung kay President Marcos at President Duterte ngayon, ano?
Kaya nga yan
Talaga.
ang namin natin bilang historiador, ipahayag yung katotohanan. Ayan ang huli yata, Atty. Bunquin.
Attorney, okay na?
Jerry, can you hear me?
Ayan, great.
Yan.
Okay.
Okay.
Yes, attorney, it's all yours now.
Ayan na. Magandang umaga po, attorney.
Morning, Attorney Ed.
Yung audio niya mukhang ano talaga, no? Good morning, attorney.
Morning, everyone.
Okay.
A pleasant morning to all of you.
Yes.
Pleasant morning po.
Jerry, can you assist me? Miss Emmy, Doc Archie, my good classmate in the graduate school.
Kala ko
Magandang umaga
kakalimutan
po.
mo.
Can I kindly request Mr. Jeric to kindly flash the slides I sent a while ago for the presentation. My other gadget is not working, the one with the slides, but magandang umaga po sa inyong lahat. I'm so delighted and I'm so happy that I'm invited in this webinar. Magandang umaga po. So can you hear me? Can you hear me? Hello, good morning.
Opo, naririnig po, attorney.
Can I request the slides, Jeric? Can we start now?
Okay na po.
Possible ba yun, Jeric?
Okay na po, attorney.
Okay, so I'm going to start on the topic about the anti-terrorism bill, anti-terrorism law. So first of all, we have to use that word as anti-terrorism already passed.
Nawala po ulit.
Okay lang po, ganun talaga kung minsan nagkakaroon po ng technical problem.
Siguro yung internet connection ni Attorney Bunquin ay medyo nahihirapan.
Maganda siguro, Jeric, pagdating ng September, talakayin naman natin yung tungkol sa martial law. Ano pa yung nito? Kasi malapit na yung September at isa sa mga mag-webinar po natin yung martial law.
Yun ang ating paksa na dapat mapagtuunan ng pansin.
Proceed.
Correct. Ulit po.
Kaya kahit may konting technical difficulties, talagang naghihintay ako na mapakinggan itong discussion na to tungkol sa anti-terror law.
I think nandyan na po, Alicia.
Ayan na sir.
Attorney?
Hindi niya talaga naririnig.
Attorney?
Siguro, Jeric, tawagan na lang din siya para ano. Anyway, sige po. So, sa...
Okay, Jeric, start.
Okay.
Ay po.
Ayan.
Okay, good morning again, everyone. Yes, I can hear you. May connector ka ba? Yes, I can hear
Attorney,
you, Jerry. Pakinig kita.
attorney, you may proceed now. The PowerPoint is ready.
So good morning, everyone. Today, I will present the topic about anti-terrorism law. Next slide. So first, the definition of terrorism. The focus of this presentation will be on the definition of terrorism. First, the historical background, the evolution of terrorism in the Philippines. And then we will discuss the topic about the Anti-Terrorism Act, Anti-Terrorism Law of 2020. After that, we will focus on some pros and cons, and then we will go to the legal analysis. Next slide. The terrorist is a term that came from France. It started from French Revolution during the time of 1794. And it was first used in the Maximilian Robespierre regime of dictatorship. During this time, it is not yet popular to all, but it's a kind of revolution, opposition against the existing government. Next. So in our present situation, when we speak of terrorism, it is a use of violence to create a kind of general climate for fear in the population. The purpose is to create fear, to bring about a particular political objective. Next. So if we will analyze the meaning of terrorism, it is always premeditated or threatened to use of the use of violence or force or any other means that deliberately cause harm to person, to property, destruction, or any other kind of means. For example, a kind of bomb explosion, a suicide bombing, a kind of destruction both to persons and to property. Next. Now, in the previous years, the purpose and the intention of this anti-terrorism is to prevent this kind of sowing a state of danger or panic or fear or chaos to the general public. So if the purpose is or coercing, intimidating the government. So here we try to come up with a connective that is or in the alternative. So any of this, if any of this exists, it's possible that there is an act of terrorism already. Okay, next, Jeric. Now, way back in 1970s, these are the kind of development that triggered the passage and the writings or the interest of the anti-terrorism. Way back in 1983, in Beirut, there was a barracks bombing. Also in 2001, which is very not so popular, but also known to many, the one in New York City, the Twin Tower bombing on September 11. Then there was the bombing of in Bali, Indonesia. Also, an act of they believe to be a terrorist act. Next, next, Jerry, please. Now, in the Philippines, is the new law on is this the first law on terrorism? The new law Republic Act 11479? The answer is no. The Human Security Act was the first one. Only that in this law, there was no word terrorism in the title, because the title itself is not giving the term terrorism, but the term terrorism can be found inside the title and inside the document content. How did the law in the old Human Security Act define terrorism? The law provided for some crimes under the Human Security Act. And the purpose of the law is sowing and creating the act committed. The purpose of the act committed is sowing and creating a condition of widespread or extraordinary fear. So in the law, there are enumerations of crime. Like for example, next slide. For example, piracy, mutiny. For example, the crime of piracy, rebellion, mutiny. So in section 3, you will see on screen now the different crimes in section 3 in the revised penal code. If any of this crime is committed, and the purpose is sowing and creating a condition or widespread extraordinary fear, panic among the populace in order to coerce the government, that is the kind of terrorism under the old Human Security Act. But if the purpose is different and the purpose is not sowing or creating a condition of widespread and extraordinary fear, then it is not terrorism. But the crime is just an ordinary crime under the revised penal code. So the crime under the old law is already terrorist activity. However, the law itself is very lenient because it must be present to all. It cannot be it must be present to all before it can be accepted as terrorist activity. If it is not one of them, even if that is act of piracy, mutiny in high seas, rebellion, insurrection, or coup d'etat or murder, but if the purpose is different from this enumeration below, that is not terrorism. Next. Now, there's another law about terrorism in the Philippines, Republic Act 10168. This act is defining a crime of those who are financing the terrorist activities, those who are giving activities to the terrorists in terms of financial support. So terrorists refers to those giving or conspiring by any means, directly or indirectly, unlawfully, which participates in the principal, whether principal or accomplice, then they do terrorism. So here, the law is already in effect as early as 2012. The first law and the Human Security Act happened in 2007. Then the other law, this one is around 2012. So Gloria Macapagal, there was a law. President Gloria Macapagal, there was a law. That's after that, Pinoy, 2012, there was a law. And this time, it's the time of Duterte, it's kind of compilation of all these laws and then come up with a new law. Okay? Let's have the next. Next, please. How about as historians, we have to trace back the act of terrorism in the Philippines even before the old prehistoric era, or even the time of the pre-Spanish era, or even the time of Spanish, even the time of the Americans, even the time of the Japanese. Let's have the next. In the Philippines, there was a different groups of people who are so-called terrorists. So, for example, in conflicts with ideologically armed and armed levels, we call them as bandits, terrorist rebels, group of branded known as insurrectos. So the names like Diego Silang, Spanish era, Andres Bonifacio, Emilio Aguinaldo, Macario Sakay, they are all considered as terrorists. Why? The government existing then don't want to legitimize their quest and their travel. So they have to discredit them and downplay their cause. Those are the first set of terrorists in the Philippines. Next. Now, going back to the 30s, maybe after Commonwealth, during the 60s, there was first during the pre-American. After the American, we have the Partidong Komunista, Hukbong Bayan, laban sa Hapon. Then the opposition, so the Communist Party of the Philippines, that is CPP, not CCP. CPP, Communist Party of the Philippines. It was formed in 1969. So this is one of the groups that are actually acting during the time of Marcos. So after that, it was branded as terrorists. Next. After this, we have the new set of people, and that's the kind of Communist Party of the Philippines. Let's have the next. Yeah. So I gave you a while ago the historical or sort of the overview of what happened from the first pre-American Spanish era, from the other parts. Those are the different parts of the Philippines. In the Philippines, the Abu Sayyaf during the time, they are the most identified in the 1990s. So after Marcos, after EDSA, the peaceful revolution, there was first the one who staged coup d'etat from Corazon Aquino. During the time of Corazon Aquino, there was so-called RAM, Reform Armed Movement. Then they staged so many coup d'etat. And after the time of Aquino, there are set of people who again organized themselves, known as religious extremist terrorism in the Philippines. And those are the people known now as Abu Sayyaf. The present government is not anymore looking at Abu Sayyaf in the time of Digoy, in the time of the president, saying that Abu Sayyaf is not terrorists. It's not. They are just terrorists of no value. And the high value targets now are the so-called communists of the Philippines. Let's have the next please. In the Philippines, there are so many studies about terrorism in different parts of the world, and I give you now the top 10 countries that suffered most of the terrorist activities since 2018. Who are the different countries that suffered most of the? First is the Democratic Republic of Congo. Number 9 is the Republic of the Philippines. Of course, we are still in the list. Then we have the Yemen, India, Somalia, Pakistan, Syria, Nigeria, and Iraq. So these are the listings as mandated and findings as of November 2019. A certain researcher known as Dominic Dudley made a study on terrorism in the Philippines and terrorism around the world and categorized them as by the ranking, Democratic of Congo up to Afghanistan. In the Philippines, although we are attacked by terrorists, allegedly, then there are also number 9 in the Philippines. Let's have the next. Yeah. Derek, next. Now, there in the Philippine setting, we have the listings of the different activities in the Philippines. These are the list of the biggest terror attack allegedly in the Philippines for the past years. So first is the Rizal bombing on around December 30, 2020. It's called Rizal bombing. It was celebrated historically and conducted on buses, ermita, and everything. So after that, the different bombings from December 30, 2000, December 30, 2000 and below. Now, in the case, Davao was not, of course, Davao was also attacked as of 2019. 2019 bombing on January 27, 2019. They were at least 14 people were killed, and at least 60 were injured during that time. So even the president's residence was not exempted to the attack of terrorists during that time. Let's have the next. Yeah. Now, let's have the next slide. So we move now to this development because of the activities in the Philippines, the terrorist activities in the Philippines are because of the different activities. There are many effects, many casualties and damages. So on separate dates, there were many laws and many activities for the attack of the terrorists to counterattack the existing terrorist attack. And one of them was the passage of this known as an act to secure the state, which was, I said, Republic Act on Human Security Act 1972. It was repealed by Human Security Act, was repealed by the Anti-Terrorism Law on its Section 56. So all of the Human Security Act was totally repealed and was already changed by the new law. This law is the new law in effect is the so-called Anti-Terrorism Law, Anti-Terrorism Act of 2020. The other parts of the other law, I said a while ago, Republic Act 10168 was partly adopted in the principles of anti-money laundering. Okay, let's have the next. Now, what are some of the vital statistics of this law? What are the legislative actions of this new law that we have? First, Senate bill. The Senate bill was passed. Jeric, next slide. The next law was the Senate bill of 1083. Then it was signed by the president into law on July 3, 2020. So there are two versions actually of this law, Senate Bill 1083 and House Bill number 6875. These two bills from Senate and the House were signed and was approved on February 26, 2020 in the Senate Bill. In the House Bill, it was approved on June 5, 2020. So that is why after passing on June 5, 2020, the President must act within 30 days so that it will become a law. The Constitution requires him to sign that bill into law. That's why the latest was July 3, 2020. So in July 3, 2020, the bill was signed into law and it took effect actually a few days ago, or specifically July 18. Now, let's move on to the meat of this discussion. The meat of this discussion will be on the terrorism as stated in the law. This new Republic Act 11479 or the Anti-Terrorism Act, we call it ATA, Anti-Terrorism Act. The law is now very explicit. The law is now very strict that any activity may be considered activities of terrorism. For example, engaging in acts intended to cause death. What are the definition of the offenses known as terrorist activities? Section 4 speaks of. Next slide, Jeff. So, for example, Section 4, terrorism is committed by any person who within or outside the Philippines, regardless of the states of execution, may be considered as terrorists. So here, focus on the screen, Section 4. Section 4 screen, within or outside. Philippine law, we know in criminal law, you can be prosecuted, you can be apprehended if you violate the revised penal code, generally within the Philippines. Outside the Philippines, there are only some exceptions that you can still be prosecuted outside of the Philippines. So, in the Philippines, in this law, even if the person is outside, you can still be prosecuted outside of the Philippines. In criminal law, there are so-called attempted frustrated, or consummated offense. But in this law, there is no stages of execution. Regardless of whether you are attempted, frustrated, or consummated, you are still liable under this terrorism law. Let us define what are the different laws considered as terrorist activities. What are the different activities? Section 4 of the law enumerates those that are considered acts of terrorism. Okay? Let's have the next. What are those activities that are considered terrorist activities? Number one, engaging in acts intended to cause death or serious bodily injury. These are all matter of reading. Seriously bodily injury or endanger person's life, or engaging in activities intended to cause extensive damage or destruction or public facility. Destruction to what? To government or public facility, public safety, public places. The law now is very explicit because it is using the term or. What do you mean by or? It means alternative. Even if it is not present, not all of them are present, it's possible that this can still be a crime or an offense. So here you will see the effect of the law is that it is becoming very strict. So even if you did not commit all, if you commit only one of this, it can be an act of terrorism. Okay? Now, let's have the next. So, engaging or, for example, developing, manufacturing, or processing, acquiring. So here, all of them are acts of terrorism in a point of alternative. So if you commit any one of them, terrorism na yan. Can be considered by terrorism. Who is the one who will declare that as terrorism? Possible, the Anti-Terrorism Council. And the Anti-Terrorism Council in one of the sections of the law are all, well, most of them are military officials, most of them are positions in the government for national security. Example, National Security Advisor, the Secretary of Justice, the ILG, and so on. Okay? Let's have the next. Next. So what is the purpose? If you committed any of those offenses before, what's the purpose? The purpose of that is to intimidate the general public, to create an atmosphere, to spread a message of fear, or influence by intimidation the government or international organization, or destroy the fundamental political, economic, and social structure in the country. So here, even any one of them is committed, that is already an act of terrorism activity. You don't have to commit all. Any one will be an act of terrorism. Okay? Let's have the next. Jerick, next please. So in the law also, the law is defining some terms that are a little bit dangerous to some. For example, any conspiracy to commit terrorism, when two or more persons come to an agreement concerning the commission of terrorism as defined in Section 4, the previous section, that is already act of terrorism. And that's punishable by how much? 12 years. So when is there conspiracy? Conspiracy when two or more persons come only to an agreement, nagkasundo lang, concerning the commission of an act, even if the act was not actually committed, if they just agree, that is already an act punishable under this law. Another one is the proposal to commit terrorism. So any person who processes or proposes to commit terrorism as defined in this law is also nag-propose ka lang. For example, you just called your friend, just called one of your friends over the phone. Can we do this? Can we put some bomb or dynamite somewhere near the government facilities? It's possible that it can be considered as terrorism already. Okay, next please. So also, for example, the mere fact that for example, you are just spreading some documents, papers that can be interpreted as inciting to commit terrorism. Pamphlet, ordinary banner, you are inviting people. But again, what is the purpose? The purpose is you want to create fear, you want to damage the government facilities, public facilities. But if you're assuming it's not the purpose is not one of those in the terrorism law, can you still be punished? Yes, you can still be punished, but on a different law, maybe inciting to other laws or inciting to sedition, as stated in the revised penal code. Next. Now, let's have the next slide. Another law that was probably punished in this, another activities that are punishable under the law for life imprisonment are those foreign terrorists. Who are those foreign terrorists? Sino ba yung mga terorista? So those are those who attempt to travel from one state to another state other than his residence or other than his place of residence or of different nationality. If they propose to stay here and they give training or they receive training, then it's possible that it can be identified as terrorism. Okay? Another one, facilitate the travel of individual to a state other than those things. Now, can there be a punishment to public officials? Public officials, yes. Public officials can also be punished during the time. So what are the penalty if a public official, whether elected or appointed, will be punished, will join terrorist activity? Then they can be punished the the terrorism law and a big penalty under the terrorism law. Next slide, Jerry. So what are the penalty? Deprivation of their retirement benefits, deprivation of their cancellation of civil service eligibility, and other activities. Okay? Let's have the next. Jarek, next please. We're now moving on to another topic, which is so here are some of the not so anti-terrorism law on section 16, 17, 18. These are not so important to me because these are topics that can be discussed in the proper court proceedings. Okay, let's have the next, Gary. Let's move on to the next topic, which is a little bit controversial. Here is the section 29, which was attacked by so many. What's the content of this section, section 29? The content of this section is that a person may just be detained without any judicial warrant for 14 days. So a person, when apprehended, let's not call him an accused. Every lawyer will say that if a person is just arrested, apprehended, will just maybe a person under investigation, invited person, or guest, they are not accused. So who are they? They are person under investigation. Who will arrest them? The one who will arrest them are those person authorized by the Anti-Terrorism Council, ATC. These are who are the members of ATC? Executive Secretary, National Security Advisor, is Secretary of Foreign Affairs, Secretary of Interior Local Government, Secretary of Finance, Secretary of Justice. So they are the one who will make allow, possible. So How many days you will be apprehended? 14 days. With warrant? No, without warrant. Until when can you be released? You can stay there for 14 days, and after a few days, you can be extended, and the arrest or apprehension can be extended for another 10 more days, making it 24 days. Now, let's me discuss this one. So the detention here is without warrant. So the warrant of arrest is not yet in the picture. No warrant of arrest. Now, what will happen to those who will be detained? They will be allowed. They will be considered as person under investigation. Okay, let's have the next. Yep, next slide. So, can the 14 days period na pagsuspetsahan lang, nakita lang na may mga pinaplano, makita lang siya na may dala na malaking bag, is it possible that he can be arrested? Possible. Can that be extended for another 10 days? Yes. What are the situations or conditions before the 10-day period may be extended? If there is further detention is necessary to preserve the evidence related to terrorism, then further detention is necessary to prevent further commission of terrorism, and you have to prove that the investigation is conducted properly without delay. So if this one may be present and any of them may be present or all of them are present, then it must be extended for another 10 days, making the detention of a person for 24 days. Let's have the next slide. Now, what's the duty of the person who arrested, the person who conducted the arrest? The person who conducted the arrest must, after taking custody, must notify in writing the judge, the nearest the place of apprehension. So it's possible to remember he is not placed in the fiscal's office for inquest. The fiscal office was not in the play yet. So the person arrested will be placed in a certain custody, and we call it sometimes a place of detention. So the date, what's the duty? The duty is to inform the judge nearest to the place of arrest or apprehension. Notify in writing the date, the time, the manner of the arrest, the location of the suspect, and the physical and mental condition. What is the next thing to do? You have to copy furnish the Anti-Terrorism Council and the Commission on Human Rights. Then, what will happen if if the person who made the arrest or apprehension failed to notify the judge or failed to perform any of this? He will be imprisoned, but for how many days? Just for 10 days. Now, the head of the facilities have the duty also. What are the duties of the head of the facilities? Take note, the law is not saying jail. The law is not saying a person will be put in Bureau Penitentiary. The law is saying facilities. So possible, it may be military camp, it may be a barracks, it may be other places in the military operation. So they have to ensure that the suspect is in good, inform him of his rights, right to counsel, right to be informed of his right to counsel, and the agencies must also be informed of the right to visit the person. For example, the relatives, you have to inform them also, and also those people that may allow to visit the person apprehended. Next. Now, so this is what we call as warrantless arrest. Technically, yes, because a person is just apprehended without the benefit of warrant. Who are the persons now under the law, a person may be arrested without warrant in any of the following. Basic, there are three. We all know that. What are the three? Those are warrantless arrests. Those in flagrante delicto arrest, those that are arrest in hot pursuit, those who are that may be arrested in if you are fugitive from justice, or in some other exception under the criminal procedure. Pero dito, here, you will see that the person arrested is not actually given the or not given the warrant given by the court. It is only as determined by the persons in the Anti-Terrorism Council. Let's have the next. Next slide. So, assuming the person was arrested, so Section 29, person was arrested. So, almost here is somewhat similar to the person arrested under the Bill of Rights on custodial investigation. Specifically, it's Article 3, Section 12. What's the duty of the person who arrested somebody or under investigating somebody? If you investigating somebody, you have the duty to inform the nature of the cause of the arrest over that person. Inform the person of his right to remain silent. Inform the person of his right to have a competent and independent counsel, preferably of his own choice. If you cannot afford a counsel, give the services of a counsel, maybe from IBP or PAW. So the IBP is being mandated by this law, the IBP to specifically participate in the assistance of the person arrested. Okay? So, can this be waived by the person arrested? Pwede bang i-waive na lang niya? Okay na, ayoko na ng counsel. Okay na ako. So, these rights cannot be waived except in writing in the presence of counsel. So, another one is informing him further of the cause of the detention. Okay? So, this can be possible also that the person to be arrested may ask for the services of a physician or maybe a doctor or maybe a relative. Allow the person arrested to communicate to his family and to his nearest relatives. Okay, let's have the next. Next slide. Now, so what is the penalty? 10 years imprisonment is, of course, possible that the person who conducted the arrest and the head of the facility, can they be given a penalty? Yes, they can be imprisoned. They can be given a penalty of 10 years imprisonment. And also the head of the facility may be also given a penalty of 10 years imprisonment if they violated the rights stated in Section 29 and Section 30 of this Anti-Terrorism Council. Next. Next slide. This is not a new law because this is not a new provision. The law also included the anti-torture law, which is fully operational in the anti-terrorism law. So, if there are evidence obtained in violation of said provision on torture, say pagkatapos maaresto, allegedly na-torture siya, nabigyan siya ng physical torture. So, at mapatunayan yan, meron siyang exemption and he cannot be, these evidences obtained in violation of his rights on torture cannot be used in evidence against him. So, hindi pwedeng gamitin ebidensya daw laban sa kanya o kahit kanino man laban sa kanya. So, let's have the next. Now, this is different on ordinary practice because a person, even if there is no information filed, can just be given a precautionary hold departure order. The one who's conducting the investigation on the person to be arrested or the person arrested can just request for PHDO or precautionary hold departure order. So the precautionary hold departure order may just be already be applied. You can already apply for uh, precautionary hold departure order where on the proper court. And where can you apply for that? Even precautionary hold departure order can already be applied even before the filing of the information in court. So yung probable cause na nakita pa lang, pwede nang mag-file. Now, upon the information is filed, upon the filing of the information, pwede na ngayon mag-apply ng hold departure order. And in the hold departure order, the following must be attached. Hold departure order application, you have to apply to the court, before the court, and inform the court of the following: complaint affidavit, attachment, passport, and photograph of the accused. Next. Let's have the next. Yeah. Now, I said a while ago that the Money Laundering Council has a role and has a play in this activity. Now, the Money Laundering Council is authorized to freeze the account, investigate the account, the money of the people who are suspected to be financing terrorism. Ang Money Laundering Council is part also, the head of the Money Laundering Council, the executive director, is also part of the Anti-Terrorism Council. So here, it's not new because under the old Republic Act 10168, that law was also part, which is the Money Laundering Council having the power to check yung kanila activity. Next, Gary. Now, they have the right to freeze the account for the possible conspiracy, for possible financing, and for possible activities of the activities conducted by the terrorists. Okay? So let's have Jewel, Jeric. This is also new because the continuous trial of is mandated by this law. So the law is asking that there must be a continuous trial, and that is Monday to Thursday, daily. Why? To expedite the proceedings. So if the case is filed in court, there must be a mandatory continuous trial on all the cases. Priority trial bali to. So in practice, usually 1 month, one trial every month for one case. But here, it must be done. So the Anti-Terrorism Council is appointed, and the members, as I said a while ago, Secretary of Secretary of Justice, Secretary of Foreign Affairs, the National Security Advisor, the Executive Secretary as the head. So these are the people who will, more or less, those person who can identify who may be given the authority to detain the people. Okay, let's have the next. So here, the extraordinary application, it can be applied outside of the Philippines or even inside the Philippines. These are the feature of this law that are not, maybe another question that may be raised in the proper court, in the Supreme Court. Okay, next. Now, moving on. So, because of the passage of the law, there are so many activities, so many opinions that were generated. Many many group of people cited, attack this kind of law. However, there are some who sided to the law. So let's have first those who are, what's the view of people, popular personalities. Next, Jeric. So you will see on the screen Senator Hontiveros and National Security Advisor. Of course, you know the sides of Senator Hontiveros. Of course, that is against. National Security Advisor, that's in favor. Anong kinakatakot nila? Itong mga law-abiding citizens ay walang dapat ikatakot. Dahil itong anti-terrorism law ay para sa kapakanan at seguridad ng law-abiding citizens. Ang natatakot dito ngayon ay yung mga sinasabing tahimik daw sila pero nagsusuporta naman sa terorista. Of course, on the side of the other one, she's saying, Senator Rontiveros, prioritize first the pandemic problem. Yun muna ang asikasuhin natin. Okay? Maayos na programa. Pangalaga sa ekonomiya. Iwasan ang recession. Ang inihahain na solusyon, magpasara ng media and everything. So, the cons and the pros. Okay, next. Jeric, next. Here, you will see all the pros. Diba? Who are those? They are in favor. Of course, you see the Secretary of Interior and Local Government, Senator Bato, Secretary Guevara. They are the people who believe that it must be passed, saying in mind that this is a good law for the Filipinos. Next. So, of course, Hermogenes Esperon, again, Anti-Terrorism Act will bring a culture of security based on legality and due regard for human life and human rights. Okay, next. Jeric, next. Just in case you want to know, the votes, the anti-terrorism bill, which originated in Senate on February 26, 2020, voted in that manner. 19 voted for yes, and 2 voted for no. So you will see who are in favor and who are believing that really this law is favor for the Filipinos. Of course, you know that. Okay? And let's have the chief legal officer, chief legal counsel of the president. Of course, he is also saying that the Anti-Terrorism Act of 2020 will preserve as powerful weapon against participants of this lawless action, the threat of which is extremely imminent during our current times. Of course, that is the chief legal counsel of the president. Let's have the next. In the office of the chief minister for the autonomous region of Muslim Mindanao, this is a statement that they also believe is also good for the country. They believe that the anti-terrorism law is really favorable for the benefit of the Filipino, for the Moro, and for all the people. Next. Let's have now the other side of the coin. But this one, this is the neutral. Neutral, of course, is the PAO, judges, IBP. They have a crucial role in the anti-terror law to protect human rights for all, which is positive. In all aspects, we always think of what is beneficial to many. Let's have the next. I said, let's have the other side of the coin. The former Senior Associate Justice of the Supreme Court, the great Antonio Carpio. He's saying that, as I said, Section 29 was the center of attacks, center of queries, center of alleged constitutionality. And he's saying that this is the deadliest blow on the fundamental constitutional right, which is the right to freedom. Section 29 extends detention without judicial warrant and without judicial charge for a total of 24 days. But first, 14 and 10. Next. The law is currently being challenged by the group of Attorney Calleja and the LaSalle brothers, Armin Luistro, and some other civic groups. They are also against, believing that there is a violation on different sections, specifically Section 4, 5, 6, 7, 8, 9, 12, and Section 29. And of course, that is Attorney Howard Calleja, a well-known professor and legal expert of criminal law. He's saying that it must be also, the anti-terrorism law is effectively estrange the power of the executive by granting powers inherent to the judiciary, making the executive judge, executive department, the jury, the judge, and the executioner. Let's move on. Next. This was the view of a good lawyer also, Attorney Theodore Te, the lawyer of Maria Risa of Rappler, saying that there are so many rights violated in this anti-terrorism law. So combining all of them, they have the in favor, against, in favor, against. What should be the best thing to do in this anti-terrorism law? There are let's have the next slide. There are plenty of attacks and question and petition in the Supreme Court. But as of that date, it seems to be that there are no decisions yet, still ongoing. So that is why it's possible that the law will be effective temporarily while there is no decisions yet of the Supreme Court. Let's have the next. Having said all of them, the best way, therefore, to approach is that always think of the section itself. The section itself in Section 2. The law itself is saying that nothing in the law shall be interpreted as curtailment, restriction, or diminution of constitutionally recognized power of the executive branch. It is to be understood, however, that the exercise of the constitutionally recognized powers of the executive department of the government shall not prejudice and must respect human rights, which shall be absolute and protected at all times. So while it's true that the executive department have power, while it's true that constitutionally the executive department have the power, they must be balanced. Balanced with what? With respect to human rights and with the respect to protect life. So this is the power of one, this is the power of the other. There must be a balance. Don't abuse too much power of the executive, disregard the human rights. In the same way, the executive department must not be diminished or must be abolished because there is just a human rights existing. Balance between the two must be always preserved and observed by the executive and the human rights advocate, and must also be absolute and must be protected by the executive department. Executive department, protect the people, protect your power, protect the country, but this one protect also the territory, the individual person. Okay, let's have the next. Jerry. So here, those are the most important concern, and I just have some other slides which was not actually flashed here because it was important consideration, just additional. In dealing with people and dealing of the government, we always think of what is fair, what is reasonable, and what is justifiable. In dealing with the power of the people, always think of what is fair, just, and reasonable. And also, remember the basic principle in the Constitution that we always protect the rights of the individual. No person shall be deprived of life, liberty, or his property without due process of law. Remember the principle of law, that the greatest principle is always the general welfare. In the landmark case of Kalalang versus Williams, we always say that in whatever the government will do, whatever the government will act, whatever the government will propose, always think of the general welfare. The general welfare of the people is always the supreme law. And it's time-honored principle that written by Justice Laurel, that the welfare of the people is the supreme law. Ang pakapakanan ng mamamayan ang pinakamataas na batas. Salus Populis Suprema Lex. Have a good day, and I hope you learned something from my discussion. Thank you very much.
Thank you very much, Attorney, for that very historical, informative, and legal analysis on the Anti-Terrorism Act of 2020. And there are a lot of questions are now raised. But before we go into that, let's have first the guest reactor for this session. So, Ma'am Emmy, you may introduce our guest reactor. Nakamute ka, Ma'am Emmy. Wala ka pong ano.
Thank you, Lisa. Sorry for that. Our guest reactor graduated in 2004 with a degree of Bachelor of Secondary Education, major in History from the University of Santo Tomas. Shortly right after, he pursued law and graduated in 2009 from the Institute of Law, Far Eastern University. He is admitted to practice his law profession when he passed the Philippine bar examinations in 2011. He was part of the faculty roster of the UST Faculty of Engineering for 6 years, that's from 2009 to 2015. For his other achievements, he became a partner in Pro Labor Legal Assistance Center in 2011, a member of National Union of People's Lawyers from 2013 to 2015, Assistant Vice President for Legal Department of Green Square Properties Corporation, petitioner against the cybercrime law and the recently passed anti-terror law. He is also the legal counsel of NutriAsia Workers, ABS-CBN Employees Association, Pambato Cargo Forwarders, pinag-isang samahan ng tsuper at operators nationwide or Piston 6, and Stop and Go Coalition. Audience, I present to you our reactor, Attorney Vicente Jaime Topacio.
Yeah. Good morning. Good morning to all, especially to my favorite ninong, Attorney Ed Bunquin. And I hope I can add spice to the discussion that he already mentioned this morning. No, itong ATL, the Anti-Terrorism Law, is a very controversial topic that our country as a whole is facing. No, considering yung mga nagaganap sa paligid natin. Anyway. Just to make it short, last July 3, 2020, na-sign ni President Duterte yung Anti-Terrorism Act of 2020. By the way, I'll try to be objective as possible and not be biased, considering that I am a counsel of one of the petitioners. No? There are already 8 petitioners pending, 8 petitions pending before the Supreme Court. And I am one of the counsel for the Center for Trade Union and Human Rights, as well as the National Union of People's Lawyers also. So, sige, the law defines terrorism as engaging in acts intended to cause death or serious bodily injury, engaging in acts intended to cause extensive damage or destruction, engaging in acts intended to cause extensive interference with damage or destruction to critical structure, developing, manufacturing, possessing, acquiring, transporting, supplying, or using weapons, and releasing dangerous substance causing fire, flood, explosion when the purpose is to intimidate the public. May sabi dito rin, no, sa section 4 is that terrorism as defined in this section shall not include advocacy, protest, dissent, stoppage of work, industrial stoppage of work, industrial or mass action, and other similar exercises of civil and political rights which are not intended to cause death or serious physical harm to a person or to endanger his life or to create a serious risk or to public safety. What's the problem with this? Ito yung binabanggit nga natin na mga, sabi natin na mga catch-all phrases. No? So sa very definition of terrorism itself, meron tayong malaking pangamba. Actually, the whole anti-terrorism law, kung ang magi-implement nito ay mga, sabihin na natin mga anghel, no? At lalo't-lalo na kung yung ating mga Dominican fathers ang magi-implement nitong anti-terrorism law, ay napakagandang batas nito dahil wala namang in favor of terrorism. The problem is, meron tayong pinangangambahan dahil nanggaling tayo historically sa human rights abuses at lalo't itong time ngayon ay marami pa ring lumalabas, no, na mga ganitong balita. So itong definition na to, sabi nga natin, that shall not include advocacy, protest, dissent, stoppage of work. Okay yan. Pero ito na, which are not intended to cause death, serious physical harm to a person, to endanger a person's life, or to create a serious risk to public safety. Napaka-broad na nito. And this is subject to an interpretation na hindi naman nag-aral ng batas yung mga mag-i-interpret, di ba? The Anti-Terrorism Council. Imagine niyo na lang, to endanger a person's life. This is very subjective. One act could endanger a person's life and be defined as a terrorist already, or a person be defined as a terrorist already. One could create a risk to public safety. One act could be interpreted to create a risk to public safety and be defined as terrorism already. And nakita naman natin, diniscuss ni Atty. Bunquin yung penalties na maaari. Andiyan yung pag-freeze ng bank accounts, andiyan yung pagde-detain, no, ng ilang araw, at syempre the stigma, di ba? Alam nyo, yung writ of habeas corpus ginawa yan to protect yung mga kababayan natin, no, or yung mamamayan para sa mga questionable pagkakahuli, no? At pagka sinubject mo siya sa 14 up to 24 days na detention, hindi mo alam kung saan i-detain ng isang tao at anong pwedeng psychologically maging epekto nito sa individual. Unang-una, bakit 14 days? Ano ba yung lohika ng 14 days? Diba? Ano bang gagawin nila dun sa, halimbawa, first 7 days? Bakit kailangan umabot ng 14 days? Meron bang scientific data to prove that magsasalita na ang isang tao or magtuturo na siya ng mga kasama niya after 14 days? So ito yung mga medyo contentious na issues dito, no? Another one, of course, is under the law, may mga additional na mga penalties na sinasabi na merong 12 years imprisonment. Threat to commit terrorism is already a crime. Inciting others or proposing to commit terrorism, voluntarily and knowingly joining any terrorist group, acting as an accessory in the commission of terrorism, na ang magde-define nga is the Anti-Terrorism Council. Okay? The law allows suspects to be detained without a judicial warrant for 14 days. Imagine niyo, that's 14 days nang walang judicial warrant. Okay, sabi nila may safeguards ito, you can call your lawyer, the police has the obligation or has the duty to report to the nearest judge or to the Commission on Human Rights. Pero again, what is the logic behind this, di ba? Sabi nila, wag tayong mangamba dahil these are all haka-haka, no? At ang purpose naman is for terrorism. Okay, sige, given na ganun. Pero ano nga ang ating reason? Ano ang ating explanation why 14 days at bakit kailangan nilang gawin ito, 'di ba? Na i-detain ng isang tao for 14 days which can be extended up to 10 more days and where? Tama si Atty. Bunquin kanina, saan natin ilalagay 'yon? Okay? A mere suspect can be placed under surveillance for 60 days. Okay, na yung social media accounts mo, yung bank details mo under the with the help of the Anti-Money Laundering Council, which can be extended by up to 30 days by the military. Okay? So, ito po ang mabilisan lang, no, na ating pananaw dito po sa anti-terror law. Number one, sa kabuuan po ng definition nitong anti-terror law nito, kahit na mga legal na gawain ay maaaring mabansagang terror activity ng isang terorista. Okay? Dahil nga po sa pagka-broad ng definition. na ang intensyon sa ginagawa ng isang tao ay maaaring bigyan ng iba't ibang kahulugan, no? Lalo ngayon, nakita natin yung case na nangyari kay Senator Bongo, yung college student na may sinabi daw na madali siyang napa-investigate ng NBI. Yung red tagging, it's very rampant right now, no, na yung mga members of the progressive groups are being termed as terorista, NPA terorista, ganyan, kahit na nasa legal ito. In fact, Sister Mary Jane, di ba, of Saint Scholastica, naka-experience nito nung nag-criticize siya sa decision dun sa ABS-CBN franchise. Okay? For 3, kahit isang tao lang ang di umano na apektuhan ng ating ginagawa, maaari kang ituring na terorista. Dahil meron ng conspiracy to commit terrorism, inciting others to commit terrorism. So again, we are now leaving the definition of terrorism to a few to a group composed of few people na lahat appointed by the executive department or specifically by the president. Maaring mabawasan, mapigilan o maling mapatawan ng parusa ang mga legal na aktibidad based on the definition nga. Kahit yung pagpuna, ito yung nakakatakot, no, na kahit yung pagpuna sa gobyerno ay maaaring sabihin na inciting to terrorism. Okay, na sapat na batayan para makulong. Another one under Section 4 also, maaaring ipalagay na lumilikha ng matinding panganib. Ito yung sinasabi natin na can create a serious risk to public safety, no? Yung mga ordinary o yung mga nakagawian na natin ng mga protesta, mga tigil pasada, yung mga strike, dahil sa broad definition na to, ganito yung pwede nilang gawin. Ano pa, yung halimbawa yung the usual na lawyer client privilege o kaya yung doctor patient privilege, 'di ba, na tumutulong ka dun sa kliyente mo. Ito under section 3 paragraph E and section 12 of RA 11479 ay maaaring sabihin na suportang material, 'di ba? Giving material support to terrorists, no? Dahil hindi din naman na halimbawa ang isang abogado na under his oath ay kailangan niyang ipagtanggol ang kliyente. Obviously, dahil hindi na na-define dito sa batas na to yung extent nun, it could be considered also na material support. Lalo yung doktor. Halimbawa, oath niya din yan na nagkalabanan ng isang rebel group, tinulungan niya dahil oath niya. Ganun din. Ang simbahan nung time ng martial law, di ba, naging sanctuary din ng mga activists na tumatakbo sa oppressive government nun. Material support na to terrorism. So, binabago na nito yung dynamics ng batas natin at saka ng kasaysayan as we know it. Maaaring makulong hanggang 24 days, sabi nga natin. Maaaring mailagay sa house arrest at hindi ka payagang makagamit ng cellphone o iba pang gamit na pang-communication, pati pag-contact sa ilang mga kamag-anak based on Section 34, Paragraph 4 and Paragraph 5. Pagkuha, no, ng ating mga naipundar na pera at samsamin ang mga ari-arian kapag nabansagan na hinihinalang terorista. Although may time lang, up to 6 months lang, pero pwede nilang gawin ito under the law. Surveillance, sabi nga natin, lihim na pakinggan at subaybayan ang mga tawag, mensahe at post sa social media, therefore violating the right to privacy of individuals. Silipin ng mga bank accounts, deposito ng mga bangko na hindi alam or walang pahintulot mula doon sa depositor. At syempre, yung due process provision ng ating batas na kahit walang lubos na pagdinig sa korte ay maaaring maituring agad na terorista ang isang organization, proscription of terrorism. Under the human security law kasi, ang napoprescribe pa lang na terrorist sa ating bansa is Abu Sayyaf. Okay? The CPP, NPA, NDF, the MILF, the MNLF, hindi proscribed yan as terrorists. Okay? Abu Sayyaf lang. Pero dito, Section 27 of RA 11479, kahit na hindi dumaan yung proscription process sa korte, pwedeng ma-declare na terrorist ang isang organization ang magde-declare ay isang terrorism council. Okay? Na sabi ko nga, binubuo ng mga members ng executive department of the government. Okay? Ulitin po natin, yung terrorism, kalaban po natin lahat. Wala pong may gusto, no, ng terorismo at I'm sure wala rin pong sumusuporta sa mga teroristang grupo sa ating bansa. Pero yung batas po natin, or itong anti-terrorism law, meron pinanggagalingan yan, may batayan yan. At ito yung 1987 Constitution. At meron pa rin yan. isa nga sa mga nag-petition against it are the framers themselves, no, sina Christian Monsod, no, at kino-question din nila yung provisions ng batas dahil nga po sa mga ilang nakikita nilang paglabag nito sa basic and fundamental rights na ng mga mamamayan based doon sa 1987 Constitution. So, siguro po yun lang yung mabilis na ano natin, no, na definition on or reaction dun sa speech ni Attorney Bunquin. It is very informative, and sabi nga natin, we have to be careful, no, these days. Before becoming a lawyer, I was also a history teacher, and I learned a lot from Attorney Ed, syempre. At nalaman natin na nung time ng dictatorship, di ba, the Marcos dictatorship, ay pinaglaban, no, ng mga tao yung karapatan nila, at nanalo, no, yung mamamayan. Ang problema natin dito is yung author nga nung anti-terror law, may mga ano din siya, may mga issues din siya before, di ba, sa human rights. Tapos wala naman talagang na parusahan, no, sa ating bansa, no, sa usapin ng human rights. Well, there is of course the case for ex-President Marcos, pero yung, di ba, maraming mga nangyari pa diyan, Dakuratong Baleleng, etc., etc. And then yung mga magi-implement naman ng anti-terror law sa ngayon ay meron din kinakaharap na human rights issues, di ba? Tokhang, 30,000 deaths, etc. So hindi natin masisisi yung mga tao kung bakit natatakot sila sa ganitong batas, no, na nagbibigay ngipin, no, dun sa estado para i-eliminate kuno ang terrorism. So siguro yun lang po, kung again maraming salamat po sa UST, no, for inviting me. Syempre diyan po tayo naging abogado rin, at marami tayong natutunan sa ating mga professors sa University of Santo Tomas, at lalo na yung values, no, ng isang Tomasian na nadadala natin sa pagiging lawyers, na sa pagiging abogado natin. So ayun po, maraming salamat sa inyo, at mabuhay po kayo lahat.
Thank you very much, Attorney Vicente Jaime. Ayaw mo pakinggan Vicente Jaime Topacio for that wonderful insight. Definitely this will add information to our viewers this morning. So thank you for being with us for this session. And now we shall proceed to Q&A. So yes, ma'am, Emmy, can I start the first?
Yes. Here's our first question from Lee Mark Banaat. Attorney, in your legal opinion, would Rizal, if alive today, would be liable to the Anti-Terrorism Act of 2020 with regards to Rizal having met and advised Pio Valenzuela in Dapitan, a known member of Katipunan who revealed its revolutionary plan in consultation with Rizal? If no, why? If yes, and as a defense lawyer of Rizal, where in the law do you see ways of him escaping the charge against him in relation to the Anti-Terrorism Act of 2020? Attorney Ed?
Attorney Ed. May problem talaga dun sa kanya, sa kanya
Connection?
Siguro ma'am, there's one question here naman for the reactor. Kung ayan, okay? Yes, attorney. Ma'am Emmy, you may repeat the question po.
Attorney Ed, here is our first question from Lee Mark Banaag. He is asking for your
Hello,
legal opinion.
Hello, Magdas, go ahead.
Pakiulit po yung tanong. Yes, yeah.
His first question is from
Yeah.
Remark Banaag.
Yeah, supposed to be this is
He is
my
asking
view.
your legal opinion.
Mm.
Should I
Would
read
Rizal if alive
again?
today?
Yes. Would they be liable
Mm.
to Anti-Terrorism Act of 2020, having met and advised Pio Valenzuela in Dapitan, a member of the Katipunan who revealed its revolutionary plan? If no, why? If yes, as a defense lawyer of Rizal, where in the law do you see ways of him escaping the charge against him in relation to the Anti-Terrorism Act of 2020?
Oh, that's a very good question. By the way, supposed to be this is my headset and this is my view a while ago while I'm discussing the topic. But because of some technical difficulties and problem, I was not able to present to you this way. Anyway, that's a good question. First of all, historically, when Rizal was visited by Pio Valenzuela, he declined. He declined to their plan of the plan of the two to stage a revolution, right? Now, on that level, there is a no violation on the part of Jose Rizal. But my view is this. My take is Rizal has the duty to report that plan to the proper authority during the time. If we don't want to stage his and support the plan of these two who was sent by the Katipunan, who were sent by the Katipunan, then it is the duty of the one who learned of the plan to give and that information to the proper authority so that he will not be liable. As a defense lawyer, of course, I will advise Rizal that, well, there is no proper operation, there is no proper communication facilities, proper means of information wherein that information may be given to the proper authority the in Malacanang or in Manila. And as an ex or an exiled person, he is not duty bound to give the information he gathered from anybody. So, on the side, report niya sa government authority, pero wala siyang communication during that time eh. Medyo malabo. I hope I met your question, Mark Lee.
Lisa?
Yes po, siguro may follow-up si Lee Mark dun sa kanyang first question. Now, this one is for the reactor. This question is from Marlon Villarin, Attorney VJ. Attorney VJ, so there's a question here for you. So the question is, have you read the IRR, or the implementing rules and regulations of the law? If so, can you give us a technical walkthrough on the legal flaws and what better policy is worth considering to rectify this? So the question is for Attorney Vijay from Marlon Villarin.
Yeah. Actually, the implementing rules of the anti-terror law is already sabihin na natin this was already mentioned here, no, in the substantial law itself, no, the anti-terror law. And what we questioned was the law itself, no. Yung paglabas pa lang ng batas na to, ito na yung aming tinanong, no, sa Supreme Court, no. Ang basis namin dito, sabi nga natin, is on its face, this is unconstitutional. On its face, this is overbreadth. So, kung ano man yung ibang mga arguments natin, these are matters that are mas magandang mas fresh na, no, na court, no. Pero yung sabi nga natin, unconstitutional clause nito na nakikita na kaagad, which could cause, no, yung sinasabi nga natin din na chilling effect, no, dun sa mga karapatan ng basic na karapatan ng mga individual para mapigilan sila at ma-exercise ito. Yan yung mga in-question na kaagad natin. As for the implementing rules and how to, again, how the government will implement it, hindi pa natin pinupuntahan yan. Dahil ngayon dun pa lang mismo sa substance, it's questionable na itself. So, pag lumabas pa yan at nakita natin obviously na meron pang paglabag ito sa ating constitution, we will question this as well. Yun lang po.
So clarification lang, attorney. So wala pa talaga yung IIR kasi I read the other day na hindi pa nga siya mapa-implement hanggat wala pa siyang IIR. So hanggang ngayon wala pa talaga yung implementing rules and regulations ng Anti-Terrorism Act of 2020.
Yes, ma'am. Hindi pa po ito linalabas. Doon pa lang po mismo tayo sa the law itself, no, na nilabas.
Okay. Okay, thank you, sir. Thank you, attorney. Yes, ma'am.
Yes, here's our third question from Professor Arlene Calara. Provided that we genuinely need the law, it must be sure that it does not violate the Constitution and individual rights. But how could that be?
Attorney, that's addressed to you. Attorney Ed.
Attorney Ed. Jerry, maybe you can flash the question again for Attorney Ed. Attorney Ed, here is your question from Professor Arlene Calara. Provided that we genuinely need the law, it must be sure that it does not violate the Constitution and individual rights. But how could that be? Attorney Ed? Mukhang talaga may problem yung connection ni attorney. Professor Arlene Calara also commented, I totally agree with Attorney Bunquin and Attorney Topacio. Based on our country's past experience, we have fears. We feel uncertainties, doubts about this.
Yes, attorney. Would you like to make a comment on the question of Dr. Calara? Attorney.
Attorney?
Sorry, hindi ko napakinig. I just came in. Ano nga po yung tanong niya?
Ang tanong po niya ni Professor Arlene Calara, provided that we genuinely need the law.
What's the question? Kindly repeat, please, Lee.
Yes. Basahin ko po uli from Professor
Hindi
Arlene
ko
Calara.
napakinig yung question. Kindly repeat, please.
Yes. Naulit na po. Hello, attorney, can you hear me? Is your audio okay now? Attorney? Attorney? Wala talaga. Maganda sanang mabasa natin yung mga question, ano? Lisa, kaya lang medyo may talagang may technology problem, connection problem tayo eh.
Baka po merong comments di ano?
Attorney Topacio.
Attorney DJ.
If you're here with us, please comment.
Yes, ma'am. Okay.
Yes.
Kaya nga po ano no, ang dinadaan po natin ito sa legal process, no, when we went to the Supreme Court, we have that apprehension of the Filipinos, no, sa batas na to. And that is also the purpose ng ating Bill of Rights. The purpose of our Bill of Rights is to safeguard the people from sabihin na nating mga unfair and tingin natin ng mga unjust measures na ilabas ng Estado. And we believe that yung basis natin for questioning the law itself is legitimate dahil this was based on history and this is also legal. So, yan nga po, totoo po yan na aminin po natin, nakakatakot yung batas dahil pag nailagay sa mga mag-implement na, na mga ganid sa power ay mas delikado mamamayan.
Okay. Yes, attorney, maybe you want to share your insights about the question of Ma'am Calara. May problem talaga yung audio ni sir, ni attorney. Sir Jeric, maybe you can just flash the question of Dr. Calara to attorney, so you can
Read it. Mm-mm. Attorney Ed, are you still with us? Okay. Jeric, maybe we can have another call.
Actually, Lee, wala ako napapakinig na audio. Walang audio.
attorney, naka-flash yung
Can you
question ni
kindly repeat? Hindi ko napakinig. Sorry. Wala ako napapakinig.
sige po, ma'am.
Naka-flash
Wala ako
po.
napapakinig. Miss Emmy, Lisa.
Oo. Lisa, even if I read this question, if Attorney Ed Bunquin is not hearing it, then
siguro
it will
ma'am,
be a
pa-assist na lang
futile
tayo.
attempt.
Yeah, that's
Yes.
correct. Maybe you can just ask Jeric to assist Attorney Bunquin. But for the meantime, since Attorney VJ is still around, maybe we can also raise question to him. Is it
Yeah.
okay? The question of Dr. Calara. Yes.
Okay. Here's one question, Attorney BJ. This is from Emil Martin Bautista, incoming sophomore from the UST Department of History. One of the things that are being questioned about the controversial ATL is about the vagueness of the definition of the word terrorism. If you were one of the authors of the act, how would you define terrorism to make it not vague and confusing?
Okay, again, no, sabi ko nga po kanina, if only the implementers of the law are really sabihin na nating maayos, matitino, wala namang question dito sa anti-terror law. The problem is, nagbe-base tayo sa nangyayari sa kasalukuyan at sa nangyayari sa nakaraan. Now, if I'm the author of the law, I'll make it sure na na yung definition of terrorism was not already defined under the revised penal code or other laws na meron tayo sa bansa. Halimbawa, arson in itself. Yung arson ba na merong elements yan na nakalagay sa batas, could it already be considered as terrorism? Kudeta and rebellion. Diba? Sa kasaysayan natin, aminin natin. Yun nga, kanina magandang tanong about Rizal, diba, sa Katipunan. Ito, mga crime to eh. Diba? Rebellion ito. This was based on kudeta. Sa history natin, we are not declaring per se kudeta and rebellion as an ordinary crime, di ba? These are political offenses. Kaya nga sa ngayon ang nangyayari, pag may nahuhuling mga rebels, ang cases na pina-file ng gobyerno ay murder, arson, hindi na rebellion, no? Kasi walang quote unquote wala nang political offender daw sa Pilipinas eh. Because rebellion in itself is a political offense. So if kung author ako, I'll be more careful in defining terrorism na hindi isama a noble attempt no na gawin 'yon, hindi sinama yung protest, dissent, etc. no sa batas, pero ayun nga dinikit naman 'yon sa another dangerous trait na which would not cause serious danger or harm to the public. So I will be more careful on defining that, tapos doon ko siguro lalaroin. But again, without touching yung mga crimes na present na no na crime on arson, a crime on murder, illegal possession of firearms, ganyan.
Okay.
Okay. Jerry,
Okay.
may we have one question?
Yes, ma'am. I will read po.
Okay,
Thank
yes.
you.
Lisa?
Opo. Before the question of Kyle Vergara, so there's one question from Ma'am Reg. Okay? Sabi niya, while the Supreme Court is still looking into 6 or 8 restraining order petitions lodged by an opposition and two groups of lawyers, how can we as ordinary citizens protect ourselves from the pangs of the anti-terror law without sacrificing many of our basic rights? Thanks. Narinig mo, attorney? So this actually sent sa aking sa messenger. Narinig mo, attorney?
Mm. Mukhang...
Maybe Attorney VJ, Attorney
Oo.
VJ, can you please answer this? Okay. While the Supreme Court is still looking into 6 or 8 restraining order petitions lodged by an opposition and two groups of lawyers, I believe nasa 14 na yata to eh. How can we, as ordinary citizens, protect ourselves from the pangs of the anti-terror law without sacrificing many of our basic rights? Thank you. This is from Professor Regina Panlilio.
Ay, napakaganda pong tanong, Prof. No? Well, based on the Constitution, sa ating Article 2 no, of the Constitution, Section 1, ang sabi dito, the Philippines is a republican and a democratic state. No? And all governed, and the republic and the democratic state, all government authority emanates from it. Okay, so the Filipinos are sovereign in itself, and all government authority emanates from them. Yung nasabi dyan sa batas natin yan. So sa madaling salita, kung alam natin na hindi tayo lumalabag sa kahit na anong or wala tayong ginagawang masama kasi nga pala meron na pwede tayo lumabag sa batas no at pinaglalaban lang natin yung ating mga karapatan yung constitution mismo natin yung nagpo-protect sa atin. Ngayon, meron bang threat or meron bang pangamba na pwede tayong masampulan itong anti-terror law na to? Legitimate po yung pangamba natin. At kasama niyo po ako dyan, no, sa sabihin na nating medyo natatakot at yun nga, nangangamba no, dahil sa kung paano mai-implement yung batas na to. Pero again, before becoming a lawyer, I was also a history teacher. At lahat ng mga dakilang mga leaders naman natin at mga bayani ay dumaan din sa ganitong klaseng pangamba. Siguro sabi ko nga, at the end of the day, this is our era, this is our period, and as Tomasians and as Filipinos, pwede nating ipakita na united tayo against a draconian law, sabi nga. And perhaps, no, I am still praying that the government can hear the plea of the people through that. There are still democratic processes na pwede nating gawin. At the end of the day, sabi nga natin, when we are all united, of course, this is already cliche, we can never be defeated. So, siguro, ganun po. Pero yun nga, legitimate yung takot, legitimate yung pangamba. Hindi po talaga mawawala yan sa panahon ngayon.
Legitimate ang takot.
Oo.
Talaga. Oo, it's really, so ito yung na-legitimize talaga ang takot natin. No? Yes, ma'am. Your
Okay,
question.
so allow me to read a question from Kyle Vergara, UST AB History, Batch 2018. And from UST Graduate School, MA History. The question is, what are the implications of anti-terrorism law, if any, to academics? After all, some of the critics of the administration belong to this group, and if there are implications, what legal remedies are available to them.
Okay. Actually, if you're going to be really technical and legalistic about the law, um, yung halimbawa yung mga classics, no, halimbawa the Das Kapital of Karl Marx, even perhaps Les Miserables of Victor Hugo. Ito, medyo ano na to dun sa broad definition, 'di ba, ng ating batas. These are materials that could incite terrorism already, 'di ba? The Cartillo Bonifacio, again, ganyan. Seriously, sabi nga natin, yung maaaring ito yung mag-cause ng chilling effect na binabanggit ko, no, na dahil takot na yung mamamayan, kahit na ituro lang yung mga classics, no, dahil alam naman natin merong rebel group talaga sa Pilipinas na nag-base sa ideology ni Karl Marx, di ba? Hindi na lang maituro sa mga estudyante ito, no, sa isang university, when in fact these are for fear of being branded subversives, di ba? Pero tandaan natin, as Christians, as Catholics, di ba, even the Bible is considered a subversive before. 'Di ba? Ang even si the Lord Jesus Christ was uh, persecuted based on his sinasabing subversive ideology. So again, if we are not careful, ito na nga ang mangyayari. You will be tagged, 'di ba? As a red tagging ang tawag diyan, 'di ba? This was very rampant in martial law for just protesting and saying or commenting against policies ng gobyerno na tingin mo hindi tama. Okay? At yan nga yung sinasabi natin na a threat to our democratic rights, and wag na nating hintayin na a direct attack to our democratic rights. So yes, academics, ang tingin ko dito, posible po talagang maapektuhan din yung pagtuturo. Although again, let's see how this will be implemented, no? Kung sino yung unang masasampulan. Kaya nga, again, balik tayo sa sinasabi natin kanina, legitimate na takot. Pero hindi natin alam kung sinong sector yung unang masasampulan dahil sa very broad na definition ng batas.
Hey,
Thank
there's
you.
another question, Lisa.
Opo. So, meron dong statement si Jeric, nagkakaroon lang talaga ng technical problem si attorney. Anyway, at least attorney VJ is here to assist attorney Bunquin. Siguro bago lang po yung question from Shara Mortega. So, there's one comment here. Sayang kasi kung di natin mabasa. The purpose of this is from Allen Bantigue. The purpose of the law is for the common good of the people. How ironic that the government officials want us not to be scared, but the law states that we can be arrested without warrant and by accusations. So yun ang sinasabi nga niya, no? For the people, and yet talagang nililegitimize ang takot natin. Okay, the question is for Shera Mortega. Good morning po, attorney. Shera Mortega, UST AB History Batch 2017 alumnus. I would just like to clarify, if the definition of the terrorism used in the anti-terrorism law is under the guidance of under the guidelines of the UN, which was used by other countries as well. If not, what is the basis of the guidelines by defining a terrorist? Attorney?
Yeah, okay. Actually, very good question. Very good question from my panyera here. No? Pero even the United Nations Human Rights Council called the attention of this administration when legislation was passed.
Well, yes, good morning. I'm back finally. So,
Nong, ano na?
Attorney Bunquin, tapusin lang po ni Attorney VJ yung kanyang sagot dun sa question ni Shera Mortega. Yes, Attorney VJ?
Yeah. So even the UNHR questioned or called the attention of this government, 'di ba? As well as other groups, no, the Amnesty International, ganyan. So kaya nga sabi natin, the definition na ginawa ng ating author nito o yung ating Congress is already questionable dahil the terrorism as it's an international, sabihin na natin, this is a international crime, no? This is an international offense condemned by all countries. Kaya nga nakakatawa na pati mismo yung United Nations, 'di ba? At yung may iba't ibang bansa including the United States, 'di ba, na may mas matinding ano nga yan, batas yan, the Patriot Act. 'Di ba? Mas matapang na batas yan eh, mas mahingipin, mapangil na batas yan. Pero sila mismo, they are questioning no yung ating batas. And yun nga yung nakakalungkot dito. Hindi natin alam kung paano umabot na ganito yung definition ng batas natin at kung bakit hindi na lang inadopt yung terrorism as defined by the United Nations. Or it's not just the definition, but kasama din yung mga acts nga o yung powers na binigay dun sa Anti-Terrorism Council na tinatanong dito. Kasi yes, the definition can be sabi natin universally acceptable, pero yung mag-i-implement again tapos the encroaching of powers, di ba, executive exercising judicial powers, these are all illegal under the Constitution. So, maraming questions, no? Maraming provisions sa batas na to na questionable, na nakikita nating questionable.
Thank you, Attorney. Yes, ma'am.
Okay, baka may meron pang ibang tanong tayo na pwedeng i-flash sa screen natin.
Ma'am, kay
Hey,
kay Dr. Deviana.
Kay Dr. Debiana. In the practice of law, laws that are not repealed are deemed to be enforced. In this case, do laws like the bandolerismo law in the early 20th century is still in force, and therefore there is no need for the anti-terror law? Wadyo po, Attorney Topacio, mukhang wala na naman po si Attorney Ed eh. Talaga pong bumibitiw yung connection niya.
Yes. Hello, Sir Debiana. Anyway, well, to be honest with you, sir, ginulat yun na naman po ako. Ngayon ko lang po narinig yung bandolerismo law nyo na po na yan, sir. Pero tama po kayo, sir. If previous law has not yet been repealed, then it is still operational under the rules of statutory construction. Pero pag paumanhin niyo po ako, sir, yung bandolerismo law natin, sir, medyo ano po ako, baka po umabsent ako sa klase ni Atty. Bunquin yan, sir. Pasensya na ho kayo. Opo.
Idagdag ko lang po yung bandolerismo kasi batas yun para sa mga tulisanes nung panahon ng Amerikano.
Okay. Salamat po, salamat po.
Opo. So, may ilang pang tanong tayo na gustong masagot despite of the limitations ng nangyayari sa atin ngayon. So, Jerry, do we still have some questions to be flashed on the screen?
Ma'am, meron pong isa dito from Tristan.
Ayan. Ito, meron po, may flash si, baka naririnig mo, Atty. Ed. Ito yung question from Allen Bantige. Good morning, attorney. So since it is already a law, it means that our heroes who fought for our freedom, a president who fight against government, is considered or even accused as terrorist.
Yes, go ahead. Ito, ngayon lang ka nakabalik.
Okay. Kababasa ko lang po ng question. Narinig mo ba? O, pauulit mo uli. Paulitin ko uli.
Yes, possible. But the one who fought in history are always against the existing government. The one in our history, those who fought on against let's say for example, the Japanese, the Spaniards, the anti-terrorism law has no application to them because they want themselves to have an independent government. The anti-terrorism law now is there is already a valid government established by the people and duly constituted by the people today. That's why the law is protecting not only the the government itself, but it's possible that they also protect the general welfare and the majority of the Filipino people. As long as the activity of one is for the benefit of the greater majority and not for individual benefit, we cannot say it's a terrorist activity. What the law is saying that it's terrorist activity if it will cause fear, damage, or injury. It will destroy the existing government and the establishment. That's the one contemplated by law as terrorism. From the word itself, a question a while ago, from the word itself, terror, it create chaos, it create damage, it create fear. Those are acts that even if there is no law on terrorism, those are inherently wrong. No need for a law to be passed saying that it is bad. If you exploded, nagpasabog ka, nakapatay ka ng madami, may nasunog, may nasirang property, hindi na naman kailangan ng Anti-Terrorism Act para sabihin na mali yun because by its very nature, it is it is wrong, it is criminal activity. Ang kaibahan nga lang nito, ang purpose ng pagkamatay o pagpapasabog is because gusto mong mag-create ka ng problem sa government. Kahit na walang anti-terrorism law, liable ka pa din kung nakapatay ka, nagpasabog ka, at gumawa ka ng distraction sa existing facilities, private or public. So that's my take on that question. Thank you very much.
So, ito po yung ating second to the last question from Tristan Miguel Osteria. What is the difference between sedation and terror? I remember there was a sedation law during the early American period.
Well, when you speak of sedition law, you're trying to invite the people to fight and revolt against duly established constituted authority, government. So here, the intended victim, the intended target is the constituted authority. But in terror, there is no target. Whoever will be affected, whether private, civilian, or government, or people, or ordinary person, they can be a victim of terror. So that's the problem as to the target. And usually, sedition is you're generally widespread, but terrorism may be only one part, then other parts. That's my view on that.
Okay,
Okay.
salamat po. Lisa,
Thank
let's have
you.
our
Yes, ma'am.
last question.
Yes, po. At thank you, attorney. So, siguro kunin ko itong kay Dr. Deviana. Sakay and Mariana Noriel were hanged for violation of the Bandolerismo Act, and there was no uproar over the law. Even Luis Taruc endured 15 years imprisonment, and there was no opposition. Why the uproar now? So, attorney, this is for you. Sakay and
Can you
Mariana
kindly
Noriel.
last
Yes po. Sakay
yeah,
and
the last part.
Mariana Noriel were hanged for violation of the Bandolerismo Act, and there was no uproar over the law. Even Luis Taruc endured 15 years imprisonment, and there was no opposition. Why the uproar now?
To, with regard to
Parang siguro sinasabi,
the incident of the
yeah, parang ngayon kasi, noon dati may Bandolerismo
I'm not
Act.
getting the question.
Yeah, parang sinasabi lang
Hmm.
ni Dr.
Yes,
Deviana, may
madam.
bandolerismo noon, tapos of course, nakilala natin si Sakay and Mariano Noriel as not really tag as terrorismo, pero mga bandolerismo. And then even Luis Taruc endured 15
Hmm.
years imprisonment. So sila tinatanong niya, bakit ngayon? Bakit ngayon may mga ganitong pagsigaw tungkol dito sa anti-terrorism law? Considering Luis Taruc nga was imprisoned for 15 years. What is your comment?
There's the principle of dynamism of law and dynamism of society. Because during that time, the people may be that passive. The people may be not properly informed of what's happening around the world. That's why maybe they are so quiet. So uh, walang pakialam, we can say. But this time, because of the developments around the world in all the parts of the Philippines, around the globe, people are now proactive and vigilant on the rights of every individual. So assuming if you will, and there was no 1987 constitution yet during the time. One of the principles of the 1987 Constitution is that penalty must be humane, must not be disgraceful, must not be demeaning. So if that situation will happen today, hanging a person or killing by firing squad, that is not aligned to the Constitution, even without the terrorism law. So the law, the society, the dynamism of all of them all together, then it brings all of them. It bring up to the people the sense of awareness, sense of vigilance. That's why they are now shouting and asking that it's possible it must be prevented.
Thank you, Attorney. And maybe
Salamat,
because
Attorney.
of the social media, right? Ang lakas kasi ngayon ng social media eh. So talagang lahat may air nila yung kanilang mga position and yung kanilang mga statement. Yes, Ma'am Emmy?
Okay. Yes. Since this question was flashed a while ago, this we're supposed to have the last question, but we need to read this and be answered by Attorney Ed. So, Attorney
Yes,
Ed, allow
please.
me to read this. Hi, I'm Joanna Pollack, Corpus, UST Philosophy, Batch 2019. I would like to ask a simple yet bugging questions. Who will guard the guardians of this act? By guardians, I mean the implementing agencies that will be tasked to enforce this law. Thank you so much.
Well, for example, that's a good question. Like an oversight committee, the law itself, inside the law itself, there is a precautionary measure. For example, Section 29. Those who will violate Section 29 for the imprisonment or custody for more than 24 days, 14, 14, and 10, there's already a built-in mechanism inside the law that those who violated that Section 29 will be penalized for imprisonment. That's one. Number two, those who will be violating the principle of that provision may also be suppressed and may also be given sanctions and penalty. Even the head of the facilities where the person is detained. I said facilities because the law is not specifically saying a jail or prison cell. It's only saying detained facilities. Pwedeng barracks ng sundalo, pwedeng kulungan lang ng basta, o pwedeng bahay lang ng isang general. Posible, may nauli ka lang. So the head of that facility may be sanctioned. Now, with regard to your question on a higher level, if you look at the if you look at the law itself, even without the oversight committee, any person who will be abused, who are believed to be overpowered by the law, they can always go to the court because the act of the executive can always be checked in the court of law, in Supreme Court, in the Court of Appeals, if there's a grave abuse of discretion or amounting to lack or excess of jurisdiction of any one of those violation. So the law itself, there's one prohibition and safeguard, and on the other side, the general principles in the Constitution on the Judicial Department, lahat ng batas na pinasa, kahit hindi itong batas na to, pwede yang i-check kung may lumabag at hindi sumunod sa sinasaad ng batas. So yan ang check, sinong mag-check sa guardian, sa guard, so lahat ng yan pwedeng i-check under the existing provision. More so, sabi nga ni Attorney VJ, kung may implementing rules and regulation, then that's the better.
Salamat, Attorney Ed.
Yeah, thank
So
you,
we have
Attorney
reached
Ed.
the final part of our webinar.
Yes.
So we expect to have another one, another webinar this coming month. Lisa?
Yes, ma'am. Thank you, Attorney Bunquin and Attorney VJ. So, naging very interesting. In fact, ang dami pa nga pong tanong from our department, from the faculty of our department. So, siguro maybe you can just raise question personally or through PM kay Attorney Bunquin and Attorney VJ. So, yes, so next month is history, will be History Month. So, to our viewers, please follow us in our official Facebook page for the update. So, marami pa po tayong mga webinar na gagawin. So, with that, thank you very much and have a pleasant day. God bless
Yes,
everyone.
salamat po sa ating speaker at reactor. Please join us in the singing of the UST anthem, hymn.